Property Rights of Spouses Act. Alteration of property interest. Section 15. Alteration of property interest. Subsection 1. In any proceedings in respect of the property of the spouses or of either spouse other than the family home, the court may make such order as it thinks fit, altering the interest of either spouse in the property, including, so the court can actually change the amount or the proportion, the percentage owed to each party. The court may make such order as it thinks fit, altering, changing the interests of either spouse in the property, including A. An order for a settlement of property in substitution for any interest in the property. So in that case, settlement of property in substitution for any interest. So B. An order requiring either or both spouses to make, for the benefit of either or both spouses, such settlement or transfer of property as the court decides. So it may make an order for either the husband or the wife or both spouses to make such settlement or to transfer the property as the court decides. Or C. An order requiring either or both spouses to make, for the benefit of a relevant child, to make such settlement or transfer of property as the court determines. Subsection 2. The court shall not make an order under subsection 1 unless it is satisfied that it is just and equitable to do so. Where the court makes an order under subsection 1, the court shall have regards to A. The effect of the proposed order upon the earning capacity of either spouse. So they will want to know how much money you make, how much money you earn, so that they don't order you to pay what you cannot pay. Or in some cases, if you are quite wealthy, earning a lot of money, they will say you should be able to pay more than what is being required. Anyway, B. The matters, or they may say that you can afford to make the payment. Anyway, B. The matters referred to in section 14, subsection 2, insofar as they are relevant, and C. Any other order that has been made under this section in respect of a spouse. Section 16. Court may set aside order made under section 15. Subsection 1. Where the court is satisfied on an application made by a person affected by an order made under section 15 that the order was obtained by fraud, by duress, or the giving of false evidence as to the suppression of material facts, the court may set aside the order and make another order under subsection 1 of that section in substitution. Therefore, let's look at that. Section 15. Under Section 15, the court may make an order that both spouses make settlement of such property. Oh, so the court may order you and your spouse to settle on the property, but that means that you are not supposed to pressure your spouse to take only 15% of the property. So if the court finds that that order, that you had committed fraud or pressured your spouse or presented false evidence to your spouse in making that order, then the court may set aside your order and make their own order in substitution for yours. Subsection 2. The court shall, in exercising its power under subsection 1, have regards to the protection of the interests of a bona fide purchaser for a value without notice. Right. So it may also be the case where your spouse had presented false evidence or defrauded you or pressured you into making that order. You can complain to the court and they will squash that order and make their own in that case. So the courts will look at protecting the interest of a bona fide purchaser, whoever would buy the property, right? In making that order, the court will consider the interests of whoever is going to be purchasing the property. All right. So, property and creditors, we'll look at that in a different video.